Hello and welcome to this webinar on confiscation the second time around. My name is David Winch and I'm a forensic accountant with Bartfield's Forensic Accountants. Okay, let's kick off. Confiscation the second time around. The agenda. First of all, I'll just spell out what the problem is or the potential problem. Then I'll go on to discuss how we deal with that in relation to repeated particular benefit confiscation orders. And then look at slightly more complicated where we have relatively quickly repeated criminal lifestyle confiscation orders. And then finally look at the implications of longer term repeated criminal lifestyle confiscation orders and the implications for Section 22 revisits. Okay, so the situation that we're dealing with is where the same defendant, normally an individual, it could be a company, but the same defendant is subject to confiscation on a second or subsequent offence. So there is a second or third or fourth or fifth confiscation order against the same person as a result of repeated offending. We're not today going to be dealing with the situation where we have an offence, for example, like a conspiracy offence, where there are multiple defendants all facing confiscation in respect of the same offence, such as a conspiracy to produce drugs or something like that. That's not what we're dealing with. We're dealing with the same defendant being over time subject to confiscation on more than one occasion. So in consequence of this same defendant being subject to confiscation on more than one occasion, there is a risk of the same benefit or the same available amount being counted twice, or some benefit being overlooked altogether. When I said there is a risk, there shouldn't be because of the way the statute works, but of course that's what we're going to explain over the next 30 minutes or so. So let's take the simplest circumstance first, which is where we have got particular benefit confiscations of not a criminal lifestyle, and that's happened repeatedly to the same defendant. So what are the implications of that? Well, let's look at benefit first. In each case, the benefit is going to be based only on the offences of which the defendant is convicted in the current proceedings, and any offences which he asks to be taken into consideration, TICs, taken into consideration in sentencing in the current proceedings. So in each case, the confiscation order stands on its own in relation to benefit. So that means that there should be no problems with duplication or omission, because of course this defendant is not going to be charged on two separate occasions with the same offence. He is going to only be charged and convicted once in relation to a particular criminal conduct. So benefit should be straightforward. The benefit figures on each confiscation stand on their own and are quite separate. What about available amount? Well, in each case, the available amount for the defendant is going to be based on a calculation made of the defendant's position on the day the confiscation order is made. So insofar as on that day there might be an amount which the defendant has been ordered to pay in a previous confiscation order and has not yet paid, note carefully what I'm saying here. Sums I'm talking about that he has been ordered to pay, not benefit. Sums he's been ordered to pay on a previous confiscation order and has not paid. Then that outstanding debt is a deduction in calculating his current available amount. And you'll see on the slides that I have detailed the particular sections and subsections within POCA that spell this out. So let's take an example, and in each each particular situation I'm talking about today, I'm going to finish with an example which hopefully will clarify the rules and how they work. Take the example of Alan, let's call him. Alan was subject to a confiscation order on the 8th of March 2017. His benefit was £40,000. His available amount then was £3,000. And so he was ordered to pay £3,000. And here I'm talking about being that £40,000 was a benefit of his particular criminal conduct. He was not a criminal lifestyle case. So there's no question of applying the assumptions, for example. Okay, so the court in 2017, in March 2017, found his benefit to be £40,000, his available amount £3,000, he's ordered to pay £3,000. So far, so absolutely straightforward. Alan, in fact, has only paid £2,000 under that order. There's £1,000 still owed that he was ordered to pay in 2017, and he hasn't paid. And in all of the examples today, I'm going to ignore interest. And the only reason I'm ignoring interest is because it just complicates all the numbers and doesn't serve any useful purpose in understanding what's actually going on. So Alan's paid £2,000 of the £3,000 he was ordered to pay. There's £1,000 still owed. Today, Alan is to be subject to a new particular benefit confiscation order. He's been convicted of some new offending. His benefit under that new offending, the court has decided, is £20,000. And looking at his financial affairs, we find that he has £7,000 in a bank account. He has no other assets, and he's made no tainted gifts. Again, the reason for these rather simplistic assumptions is just to make it clearer what we're actually doing here. If he's got cash in a bank account, there's no question of its realizable value or any sort of problem with anything like that. So today, he's going to be subject to a new confiscation order, benefit £20,000. He's got £7,000 in a bank account, but nothing else. Alan's benefit under this new order is going to be £20,000. That's the benefit of the offending of which he's been convicted in these proceedings. No problem there. His available amount today is £6,000. And the reason it's £6,000 and not £7,000 is because we have to deduct from the £7,000 the £1,000 which is still owed under the old confiscation order. That is a deduction under subsection 2A of section 9 of POCA. So his available amount today is £6,000. So the court is going to order him to pay £6,000. He's still, of course, got the liability to pay £1,000 in relation to the order that was made against him in March 2017. Okay, so hopefully that is very straightforward and very clear, and we know what we're doing with particular benefit confiscations. It gets slightly more complicated where we've got criminal lifestyle confiscations. Let's look at the benefit here. In later confiscations, so we're assuming that he's already had one criminal lifestyle confiscation, and he's now going to have a new criminal lifestyle confiscation. In later confiscations, the relevant day cannot be earlier than the day on which the last previous criminal lifestyle confiscation order was made. Again, I've given you the statutory reference, section 10, subsection 9A. The relevant day, of course, typically is 6 years prior to the date of charge. But if that takes you to a date before the last previous criminal lifestyle confiscation for this defendant, then you would have an overlap period, wouldn't you? You would have a period where assumptions were applied in the previous confiscation hearing, and assumptions are going to be applied to that same period in this new latest confiscation hearing. Well, that can't happen. You can't have that duplication. So the relevant day by subsection 9A is set at the date on which the latest previous criminal lifestyle confiscation order was made. And so the transfers received and expenditure incurred assumptions apply from the day after the relevant day. That's again in section 10, subsections 2 and 4. And that means that there will be no overlap period which is subject to assumptions twice. The day up to the date on which the confiscation order was made was covered by the assumptions in the previous criminal confiscation order. The day after that is caught now by these assumptions. And the property held assumption does not apply to property held on the day on which the latest previous criminal lifestyle confiscation order was made. Again, I've given you the statute there, it's section 10 sub 9b. Okay, so the total benefit in the latest confiscation order will include the benefit found in the previous confiscation orders, less the amounts ordered to be paid under those orders. The statute there, section 76, tells you that somebody's general criminal conduct is all his criminal conduct. Subsection 2A of section 8 tells you that the court, when it's making the order, is required to consider conduct up to the day on which it makes the order. And subsection 5 of section 8 tells you how to deal with the combination of previous benefit and current benefit where you're making a new criminal lifestyle confiscation order. There's going to be an example in a minute which will make all this perhaps a little bit clearer. So there should be no problems with duplications or omissions if the earlier confiscations have been done correctly. Available amount, very similar to last time. The available amount is based on a calculation made of the defendant's position on the day the confiscation order is made. And insofar as on that day there is an amount which the defendant has been ordered to pay, but has not paid, in respect of an earlier confiscation order, that debt will be a deduction in calculating his current available amount. So we saw that a few minutes ago in relation to particular benefit. Exactly the same happens in connection with criminal lifestyle, general criminal conduct benefit. So let's do the example, which hopefully will make all this a little bit clearer. Let's look at Brenda. Brenda was subject to a confiscation order on the 8th of March 2017. Her benefit in that order was £400,000. Her available amount then was £30,000, and she was ordered to pay £30,000. Again, hopefully that is very straightforward. What's actually happened since then is that Brenda has only paid £20,000 under that order. So there is still £10,000 owing under that order that she was, I'm talking about here an amount she was ordered to pay, not her benefit, an amount she was ordered to pay and she hasn't paid. So she still owes £10,000 in relation to the confiscation order made against her in March 2017. Today, Brenda is to be subject to a new criminal lifestyle confiscation order. Brenda was charged with new offending on the 16th of January 2018. The relevant day, well, normally we would say, wouldn't we, that the relevant day is going to be 6 years prior to the date of charge. So the relevant day is going to be sometime in 2012. But no, not in Brenda's case, because if that happened in Brenda's case, then the period between 2012 and March 2017 would be double counted, wouldn't it? We'd have assumptions applying in that period, and we've already had assumptions applying in that period when she was subject to confiscation last time. So the legislation says that the relevant day here cannot be earlier than the 8th of March 2017, the date of her last previous criminal lifestyle confiscation order. And so that will be the relevant day 8th of March 2017. So the assumptions are going to apply, aren't they, to a period in these confiscation proceedings. They're going to apply to a period which commences on 8th of March 2017 and ends today when the confiscation order is made. Her benefit arising since the 8th of March 2017 is £200,000. She has £70,000 in a bank account, no other assets, and she's made no tenanted gifts. Again, we're just keeping the available amount simple, money in the bank. We're ignoring interest just to get the example relatively clean and straightforward. The key here, of course, is that the relevant day is not the, if you like, the normal relevant day. The relevant day is going to be the date of the previous confiscation order, because that was within the last 6 years. So what are the implications for Brenda? Well, Brenda's benefit in the new confiscation order is going to be £570,000. Why is it going to be £570,000? Because she's got new benefit of £200,000, which has arisen since the date of the last confiscation order. And there is also the £400,000 of benefit, which was found by the court in 2017. And don't forget that under criminal lifestyle, we're talking about all her criminal conduct. That includes the criminal conduct which was considered in the previous confiscation case. So all her criminal conduct, we know that as at 8th of March 2017, the court found as a fact that her benefit up to that date was £400,000. We can't go behind that now unless she appeals against that 2017 confiscation order. So we've got an established figure of £400,000 benefit in 2017, but we need to knock off the £30,000 which she was ordered to pay. So that means her benefit for the purposes of this confiscation order is going to be £570,000, £200,000 of new benefit, £400,000, if you like, of old benefit, less a £30,000 deduction for the amount she was ordered to pay previously. And what's her available amount? Well, we said that she got £70,000 in the bank. But we also said, didn't we, that she owes £10,000 still on the old confiscation order. So Brenda's available amount today is £60,000, which is the £70,000 she has in the bank, less the £10,000 still owing under the old confiscation order. So that means, doesn't it, that the court is going to order her to pay, in the new confiscation order today, the court is going to order her to pay £60,000 because that's her available amount and it's less than her benefit. Okay, hopefully that all makes sense and you can see where all those figures have come from and why. What about where there is a defendant who is subject to repeated criminal lifestyle confiscations, but they are further apart, they are more than 6 years apart? What are the implications then for the relevant day and for the benefit and so on? Well, let's have a look at that. Benefit. In the later confiscation, the relevant day cannot be earlier, as we've said, than the day on which the last previous confiscation order was made. But if that was more than 6 years prior to the date of charge, then the relevant day will be calculated in just the usual way, 6 years prior to the date of charge. Okay, I'm glossing over the fact that there are some other bases on which the relevant day can be calculated, but you get the point. If the normal relevant day does not come prior to the date of the last previous criminal lifestyle confiscation order, then you just use the normal relevant day. The transfers received and expenditure incurred in assumptions apply from the day after the relevant day. That's what we said last time, that's still the case. And the property held assumption, again, does not apply to property which was held on the day on which the latest previous criminal lifestyle confiscation order was made. So, for example, I've got a house which I actually purchased in the 1970s. If I'd been subject to a confiscation order, let's say 10 years ago, then the value of the house at that time would have been assumed benefit as property held after the date of conviction. If I'm now convicted today and subject again to a new criminal lifestyle confiscation order, if that house value was counted again as benefit, then there'd be a duplication, wouldn't there? So subsection 9b of section 10 sets out that the property held assumption does not apply to property held by the defendant on the day on which the latest previous criminal lifestyle confiscation order was made. So the total benefit in the latest confiscation order will include, again, the benefit found in the previous confiscation orders, less the amounts ordered to be paid under those orders. Exactly the same provisions, they apply in exactly the same way. Again, we'll do an example in a minute, and that should make it absolutely crystal clear. And there should be no problems then with duplication or omission if the earlier confiscations have been done correctly. What about the available amount? Well, in each case, the available amount is based on a calculation made of the defendant's position on the day the confiscation order is made. And insofar as on that day there is an amount which the defendant has been ordered to pay, but has not paid in respect of an earlier confiscation order, that debt will be a deduction in calculating his current available amount. So this is exactly what we said previously. So let's take an example to spell that out. Cyril. Cyril was subject to a confiscation order a long time ago, on the 8th of March 2010. His benefit at that time was found to be £400,000. His available amount then was £30,000. He was ordered to pay £30,000. And we're assuming all the time that there have been no variations to these confiscation orders under section 23 or under section 22. The reason we're assuming that is, again, just to keep it relatively simple, to underline the point that we're actually making here. So, yeah, Cyril subject to confiscation order 10 years ago, 8th of March 2010. His benefit then was 400,000. His available amount then was 30,000. He was ordered to pay 30,000. Cyril has only paid 20,000 under that order. And so there is £10,000 still owed under that old order. And again, we're ignoring interest just to keep things relatively straightforward and simple. Today, Cyril is to be subject to a new criminal lifestyle confiscation order. He was charged with offences on the 16th of January 2018, which form the basis of him having a criminal lifestyle for POCO purposes. So the relevant day, 6 years prior to the date of charge, will be the 17th of January 2012. Let's say his benefit arising since the 17th of January 2012 is £500,000. Now, note here that he was subject to criminal lifestyle confiscation order on the 8th of March 2010. His statutory assumptions will have applied up to 8th of March 2010. We're now saying that statutory assumptions apply from 17th of January 2012 up to today. So there is a period, isn't there, between the 8th of March 2010 and the 17th of January 2012, which is not covered by any statutory assumptions. Well, that's just the way it is. So his benefit arising since 17th of January 2012 is £500,000, let's say. And he's got today £70,000 in the bank account, but no other assets, and he's made no tainted gifts. Where does that leave us? Well, Cyril's benefit in the new confiscation order is going to be £870,000. That's the £500,000 of new benefit, which he's had since January 2012, plus the £400,000 of benefit that was found when he was subject to a criminal lifestyle confiscation order in 2010, less the £30,000 which he's been ordered to pay under the order that was made in 2010. So that gives you £870,000 as his benefit figure in the new criminal lifestyle confiscation order. And his available amount today is going to be £60,000. And that's the £70,000 which he has in the bank, less £10,000 still owing under the old confiscation order. So he's going to be ordered to pay today £60,000 under the new confiscation order made today. Benefit 870,000, available amount 60,000, ordered to pay 60,000. Okay, I hope that has made clear the different types of situation that you can be in with the same defendant being subject to repeated criminal lifestyle confiscations or repeated particular benefit confiscations. I did say that we were not going to look at section 22, but let's just mention what the implications are for section 22 revisions. In relation to repeated particular benefit confiscation orders, each order exists independently, and there would be no inherent injustice in pursuing section 22 applications to revisit the amounts ordered to be paid under all of those orders that he has against him. If he's only got particular benefit orders against him, then section 2 applications simultaneously under all of those orders would not be inherently unjust. What about the situation where he's got repeated criminal lifestyle confiscation orders? Well, here it is going to be different, isn't it? Because a running total operates so that the latest criminal lifestyle order incorporates all the defendant's benefit, which he's not previously been ordered to pay, then there would be, wouldn't there, an inherent injustice in pursuing section 22 applications under any of the earlier orders if the latest criminal lifestyle order has been made properly. Because under the latest criminal lifestyle order, all the benefit which he's obtained previously, which he's not previously been ordered to pay, and that's what section 22 is aimed at, isn't it? It's benefit that's been established, but the defendant has not been ordered to pay it. All of that is now picked up and included in the latest criminal lifestyle confiscation order. So if you're going to make a section 22 application at all, it's going to be based on the latest criminal lifestyle order only. So the position there is rather different from the position where you've got particular benefit only. Okay. So what I am going to do is, in a fortnight's time, I'm going to look more generally at section 22 revisits, because they are a topic that causes a fair amount of grief. They are not well understood, and we need to, well, prosecutors need to get their section 22 applications right. Defense lawyers need to critically examine section 22 applications and make sure that they are right and they are just. Okay, so how can we help? Well, Bartfield's Forensic Accountants remains fully staffed. We undertake legal aided and privately funded criminal and civil forensic accountancy work. And it's relatively easy for us to conduct the bulk of our work, fortunately, to conduct it remotely using our up-to-date and secure IT facilities. We remain readily contactable by phone, by email, and online. And of course, our recently updated website is full of useful information, and that's accessible 24/7. You can find more on this topic on our website in the area referred to as Insights, and this and previous webinars can be found in the seminars section of the website. We do have on there recordings of all the previous webinars available to view. Also, this one will be on there in a few days' time once we've got the recording sorted. We will also send you a link to a free recording of this webinar. We'll email that to you. And if you've got questions, then do please email me. My email address is there. It's much easier to do it for me on email rather than phone, because on phone, you know, you don't get all the facts straight away, and you do need a bit of time to think sometimes. So yes, please email me with any queries you have, and I will certainly help you in any way that I can. Thank you very much for your time. We have run a little bit over the 30 minutes. I hope you'll forgive me, and I will look forward to seeing you in a fortnight to discuss section 22 revisits. Thank you again, and goodbye.